Cross your fingers that all this stuff works. And my glasses don't fog up in my trip. So here we go. The Trade and Intercourse Acts were early federal laws. Sometimes they are referred to as the Non-Intercourse Acts. All right. Just remember that these are early federal laws that specifically intended to affect both international trade and Indian policy, United States Indian policy. Okay, the intercourse term refers to trade, basically. Okay, and to some degree diplomacy. Okay, and that is, of course, according to the federal Constitution, that is the purview of the United States federal government rather than the states. Okay? So remember, the United States didn't exist in its current form in terms of its federal structure until the Constitution was ratified in 1789. The Constitution was written, mostly composed, in 1787. And that is, 1787 is a pretty consequential year for a lot of reasons, we'll see. But at this point, there are several trade and intercourse acts. The ones that you want to be concerned most with are the ones from 1790, 1802, and 1834. Those years are actually very two of those are very consequential, and we'll talk about 1802 and at least 1832 and 1831 later. So, very important federal laws taking place or being passed. So, and these begin to set what we might call sort of the structure or the basic pattern of Indian law within the United States. Here are some of the basic policies that were established or maybe solidified, defined by this series of statutes. I often will say statute, okay, or statute law, and that simply refers to federal statutes, laws passed by Congress, signed by the president. So those are different than treaties, but they're still treaties and federal statutes and the Constitution are all law of the land. The statutes, of course, can be, they can be repealed, they can be found to be unconstitutional. But anyway, this is the way it goes. Initially, what this did was it laid out the exclusive authority of the federal government over Indian affairs, so that the states would not be engaged in Indian affairs. Remember, Indian affairs, the policy that the United States had with different Indian tribes, was considered a security issue. All right? So even though we have, every state has its National Guard today, defense of the United States is federal. Okay, it's the role of the federal government. So this is similar to that. The Indian country, the name of this class, was established by boundaries. This is what this initiates that process of delineating and demarcating the territory of the various Indian tribes from that which had been acquired by the United States. Now, need to kind of back up a little bit. You recall that there were 13 original colonies and 13 original states. Can you name the 14th and the 15th and the 16th states? What are they? Not necessarily in order. No, this is all before Ohio, but we're leading to Ohio. That's kind of the point. Huh? No, Georgia was a colony, and it was an original state. Well, you may not be so much familiar with the New England states, but New Hampshire was a colony, and it was one of the early states, but its neighbor, Vermont, was not. Vermont was not. It was part of the colonies. It was actually part of New York, but Vermont sort of broke away from New York, and it was not considered it was not considered one of the original states. It's like the 14th state. So at the time of the American Revolution, the Vermonters considered themselves a republic. Okay. Anyway, they became the very first state and to join the Union. And then you also probably realize that Kentucky and Tennessee came in initially as states that were basically the western territories of Virginia and North Carolina. Kentucky was basically the western territories of Virginia. Virginia was, of course, claimed a gargantuan area, essentially the entire northeastern half of the country from the Mississippi River east, except for the original colonies. But anyway, Virginia was the mother of Kentucky, and North Carolina had these western lands that eventually became the state of Tennessee. And if you're familiar with American history, you know that eastern Tennessee, East Tennessee was the location of some of the early settlements that were located on the western side of the Proclamation line. So they were illegal. And they attempted to establish the state of Franklin and so on. But what I'm getting at is that by the time of the United States Constitution and by the time of what is referred to as the first land ordinance, known as the Land Ordinance of 1785, I don't really want you to necessarily worry too much about it. But the Land Ordinance of 1785 is the federal law that set out the process of creating new states, including surveying the land and establishing the public land survey system that we are all familiar with. That produced a grid on the surface or on our maps. 1785, though, is the year that states quit coming into the Union without following a formal territorial process. That formal territorial process was initiated in the Land Ordinance of 1785, but it was formalized and really elaborated on in 1787. Now, the Land Ordinance of 1787 goes by a more familiar name as the Northwest Ordinance. Okay, the Northwest Ordinance, the land northwest of the Ohio River, was its focus. But the Northwest Ordinance of 1787 is essentially the first Trade and Intercourse Act. Okay, I mean it's very similar, because what it does is it gives the authority of the federal government over states, saying that that any relationships with the Indian tribes is the purview of the federal government. Now, all of that said, kind of the reason I mentioned all this is because before 1787 and before the American Revolution, the colonies and some of the states after the Revolution, after independence, made treaties with Indian tribes. Not only did they make treaties with Indian tribes, they established they purchased land from Indian tribes, okay? And this was not a problem until the Land Ordinance of 1785 and the Northwest Ordinance of 1787. And, of course, the Constitution, which totally broke any relationship between states and tribes. But the point of this is that during that early, and I'm really not even talking about this particular chapter, I'm going back to pre-United States. The authority over Indian affairs before American independence was with the sovereign, okay, and the sovereign being the British Crown. So the United States, before the United States, we were colonies, and the colonies were generally separate. They were not united until they consciously tried to unite. The colonies were all kind of disparate. They were all very different. They had developed for different reasons. They had different populations. They had different populations because of different motives for people migrating to them. So they were very different. And the authority with the authority over Indian affairs of the colony was essentially the business of the governor of the colony. All right? A colonial governor was basically the hand of the king. Oh, I guess that's kind of a term that just came to me after I watched Game of Thrones. The hand. It's essentially the hand of the king, right? So basically he's the agent of the British Crown. And as the agent of the British Crown, he was responsible for doing whatever the British government wanted to do in terms of Indian affairs. This is one of the reasons why, after 1763 and after the proclamation line, the governors of the colonies, they were responsible for regulating the movement of settlers, across the proclamation line. They were seen to be the arm of the British government that was intending to enforce British policy, British Indian policy. And of course, British Indian policy between 1763 up to the American Revolution was to try to settle any disputes, and the term was pacify the tribes in order to maintain the peace. It was very essential that the British wanted to maintain the peace between the colonies and the tribes. So the royal governor was the hand of the British Crown, and the British Crown had sole authority over relationships with the Indian tribes. Okay, the states or the colonies and some of these colonial governors had made treaties with the tribes. Okay, so this is kind of an odd part, but the eastern seaboard of the United States includes, once those colonies became independent states, they also took over the authority over Indian tribes. So it passed to them. So the eastern states, in some cases, recognized Indian tribes. Okay, and most of those were also federally recognized in time. But it's just kind of an odd part of this story. Okay, I want you to realize that. But remember, the other side of that is, okay, the colonial government included not just the governor, but also, the colonial, what was essentially a legislature, and that legislature was typically popularly, elected. It was made up of the colonists and represented the colonists. So that's where the crown in the governorship and the legislature, or whatever they call it, at Burgesses, House of Burgesses or something. That's where they butted heads. But all that changed pretty much after 1787, 1785, certainly with the Constitution, and the authority over Indian affairs was moved to the federal government. All right. So these laws attempted to, and you'll find this interesting, these early laws tended to protect against non-Indian incursions or encroachment, whatever you want to call it, into Indian country. In other words, the laws attempted to hold settlers back and keep them from overrunning the lands of the tribes, for the very same reason the British government did that. Okay, I mean, it was just pragmatic. It prohibited whites from purchasing land from the Indians. Okay, that couldn't be done with very early. Why would that be? Why would the federal government prohibit whites from purchasing land from Indian tribes? Well, we'll see in just a minute, okay? There's a very good reason. And it's mostly, about security, national security. It also prohibited whites from settling on or entering Indian country for whatever economic reason, hunting or grazing. It allowed certain individuals who were licensed traders to be within Indian country, but they had to be licensed with the government, supposedly. So anyway, that was the next line there. They were subject to federal regulation, traders. And then any non-Indian depredations on Indians, on people within Indian tribes, was made a federal crime. Okay? So the government's doing its very best to stop its people, its citizens, not subjects, its citizens, from interfering with the relationship, the government-to-government relationship between the United States and the Indian tribes, the other sovereigns. It even provided compensation to the victims of either side. So if an Indian tribe came to the federal government and complained and said, "Look, these whites have come in and stolen horses," something like that, okay, or stolen corn, then the United States had agreed to compensate the victims of theft, depredations. So, and it also provided a way to compensate losses to Indian raids by whites, okay, or by the Indian raids of white settlements. But it didn't do this. This is very, very important here. It did not attempt the Indian or the Trade and Intercourse Acts or the Non-Intercourse Acts specifically did not attempt to regulate the conduct of native peoples against others within Indian country, within the Indian country. So outside of the states and outside of the territories, later we would have territories, native peoples were left alone. And legally they were supposed to be left alone. The United States federal government did not have any authority over the actions of tribes against other tribes, or the, say, criminal punishment of native peoples by their tribes. All right? There wasn't a lot of capital punishment, but that's the sort of thing that we need to be cognizant of because it will change. All right, so we begin to make treaties. There was, I think, the earliest treaty, if you want to call it a federal treaty, because it's after the Declaration of Independence, would be like 1778 with the Delaware, I think, the Lenape. And then there were a bunch of other ones in the early 1780s, like the Treaty of Holston with the Cherokees and the Creeks. So most of those treaties were designed, early on, the treaties were designed to do one thing, and that is to establish peace and establish the authority of the federal government to keep citizens of the United States from encroaching on Indian country. And also to delineate Indian country from... All right, now we move into the end of this period, moving up to the removal era. And your textbook treats this particular case, Johnson versus McIntosh, as part of this era, part of this early treaty era. And then brings in these other two cases in the 1830s in the removal era. But I don't see any reason why we should do that, because they were often referred to as the Marshall Trilogy. We'll have a few other trilogies in terms of case law, but these are Supreme Court cases that were heard by Chief Justice John Marshall. We talked about him. He's very influential in terms of Indian affairs. His rulings, in fact, his precedents, or at least the precedents that were found under his reign, I guess, affected the McGirt decision. All right? The definition of Indian country. So it's still highly relevant today. You got to know about these things. Okay, Johnson versus McIntosh. You read about that? Let's see. Hang on just a second. There we go. Let's see. We want this. Oh, maybe it's here. There we go. Oh well, forget that. I thought there was a way I could do this looking at notes. All right. So the case of Johnson versus McIntosh, 1823. It didn't even involve either of the parties involved were not even Indians or members of Indian tribes. It all involved a matter of property and title to property. Basically, it was one of these parties had purchased land, and that land had been supposedly sold by a member of a tribe. And it was even before the Constitution, so it was very iffy. Now, the question was, was the title to the land at the time of the sale, was it Indian country, or was it Indian title, or was it something else? Was the Indian title had it been removed yet? And Marshall found that this is really not any of the details of the case, but basically the land sale had to be nullified because it was found that the land had not passed out of Indian hands, had not passed out of tribal ownership. Okay? And since the land had not passed out of tribal ownership, the United States would not recognize a clear title to the land. So that means that the person who was trying to purchase it would not be able to have a fee title, a fee simple title, meaning that's property. That's your own personal property. Right? We have titles to property that is, that is expensive, right? We have certain types of instruments that declare our ownership of some, or what we might call our interest in that property. Of course, real estate is the one that most people think of. So, right now, my property is, I supposedly own it, but really there's a lien against it because I'm paying a mortgage, right? And that mortgage is gives the authority of the bank to repossess it if I don't pay the bank on time. So they would foreclose on me, I guess. So that's an important matter of title. Who exactly owns this? Another one, of course, is probably all of you have a title to your vehicle or to your motorcycle or your boat or something like that. So that's it's a registered record of ownership. And you might recall, where is that title to your car registered? Is it registered with the federal government, or is it registered with the state? With the state, yeah. So you go to the county, wherever you want you reside, or wherever. It doesn't really matter what county you go to, but the record of is held by the state and not by the federal government. So property ownership is essentially something that is considered a matter of state authority. In fact, resources in general are usually considered the purview of state authority. Okay, so the result of this was that since this was Indian country prior to the conveyance of the land, then there was no possibility for this individual to actually take possession and have a title for it. Okay, so it's null and void. Now, this led to basically what happened was Marshall wrote a very long opinion about this, and you've read that, right? Or at least you've read part of it. So do you just get part of it or the whole shebang? Yeah, it's pretty long. So be sure and read that very carefully. All right, Johnson versus McIntosh, one of the top 5 laws with regard to our course. What Marshall did was he interpreted this relationship between Indian tribes and particularly Indian land and the United States. And what he found and the way he interpreted this was he went back to, remember that? The doctrine of discovery. He goes all the way back to this sort of theoretical or hypothetical thing of European exclusivity, and the idea that the Europeans have control, and whatever state, certainly countries can pass authority back and forth, but that can only be legitimate if it's between sovereign states. Now, there's a difference between a state and a nation. You know that? You've heard of that? Okay, so a state is territorial, whether it's a democratic state or a authoritarian state, whether it's a federal state, whether it's a unitary state with only one government. Federal government has 2 sovereigns, the states and the United States federal government. And there are a lot of federal systems today, but states are territories, and they are typically run by governments, okay, most of the time. A nation, in formal terms, even though we use the term interchangeably when we're talking about our country, nation in the formal sense refers to a group of people who have a similar history or a common identity, who share a belonging to that particular group. So a nation is, very, very similar to an ethnic group, right? It's possible that a nation could be a single ethnic group, but most of the time a nation is made up of more than one ethnic group. Sometimes it's a multi-ethnic nation. It's possible. The Swiss, for example, are a great example of a nation of people. They're Swiss first, but yet they have Italian ethnicity or German ethnicity or French ethnicity. So, but being Swiss is first. That's their nationality. The Creeks, okay, the Creek Confederacy or the Powhatan Confederacy or other confederacies, tribal confederacies, were multi-ethnic or at least they were multilingual. So I think we can pretty much guess they were multi-ethnic. Creek Nation particularly. The Creek Nation comes out of the Creek Confederacy, right? So what Marshall finds is that only sovereign states can transfer territory to one another, in this ultimate sovereignty, which would include things like, what happened after the Treaty of Guadalupe Hidalgo, right? Which was the transferal of most of the western United States to the United States from Mexico after Mexico's defeat in the Mexican War. So that's recognized by Marshall. Okay, but he says that the United States has exclusive title to what Britain had after the war. So in 1783, when that formal peace treaty was signed, what was the British Crown's became that of the United States. All the territory claimed by the British Crown became the territory of the United States. The authority over that territory became that of the United States. And so, the United States considers itself to be exclusive to the ability to transfer territory within its own country that is not held in private fee simple title. Okay. We also have to remember that, here's a quick story. I'll try to make it quick. After the Constitution was ratified, in fact, one of the big reasons the Constitution was ratified was because all of the new states most of the new states were terribly in debt, right? They had these huge debts from the war. They didn't know how to get out of these debts. So part of the idea of a constitution and a federal government came about that when they were negotiating this, the Federalists, said, okay, well, this is what we'll do. All of the states will have their debts forgiven by the federal government in exchange for the land claims that the states have. Because remember, after the independence, the states still considered themselves to be sovereign, independent states. That's why we had a confederation Congress rather than a federal Congress. So they considered themselves individual states, kind of like the European states, before the European Union. So or after the European Union for that matter. So they considered themselves different. And so the federal government said, okay, we'll take your western lands that you don't have settled or surveyed yet, and we'll call all of that land federal land. We'll call it the public domain, owned by all of the people of the United States. All of the people of the United States is the sovereign too. That's the idea. So the federal government took the western lands from the indebted states with the intention of selling those federal lands to individual settlers over the coming years. The idea of the sale of federal lands would work to pay off the debt and also to run the federal government. Okay? It was not a good plan, I'll put it that way. All right? But that aside, basically there was this public domain after the Constitution was signed. And that public domain became federal land. And so any land that was not owned or within the boundaries of a state was United States territory. And of course, the indigenous peoples lived there. And the United States realized that there were many nations of people living in this area. And they also realized that many nations of people recognized their own territory. Well, sometimes those territories overlapped. They realized that. I'm talking about the federal government. So, it was kind of a dilemma. The United States had a huge area of land west of the Appalachian Mountains, all the way to the Mississippi River. It had a very large population. It was encompassing a large population of people who were not United States citizens. Very odd, isn't it? The entire population of this western area, this public domain owned by the people of the United States with exclusive title, was possessed and utilized by, we could say hundreds of different native groups. So how to deal with that? Marshall deals with that by saying the United States has exclusive title, but the Indian tribes have what he called original Indian title. This original Indian title is today sometimes referred to as Aboriginal title when we're looking at other indigenous groups around the world. But the idea of original Indian title was essentially outlined by John Marshall in 1823. Okay? And what he meant by that is the tribes who possess the land and who claim land as theirs have a just, that is a legitimate, and he says now legal claim or right to occupy and live off the land as they desire and to retain possession of it, but not to dispose of it, sell or convey it. So now you see that there was, even in 1823, if you're thinking about this, you'll know that in 1823 there was, we had a federal system with two sovereigns. We call that compound sovereignty, okay? And a compound republic means that wherever you may be, unless you're in a United States territory, wherever you may be, you can be a United States citizen and you can be a citizen of the state. All of us are, right? How many of you are citizens of the state of Oklahoma? How about other states? Okay? So, are we all citizens of the United States? Yeah. At this point, it becomes, theoretically, Native American people became citizens of nothing. They were citizens of their tribes. That's all. They were not citizens of a state, obviously, in the West, and they were not citizens of the United States. Very important detail. So basically, there are all these foreigners out there, okay? All of these foreign nations of people on our land. The United States says this, okay? But John Marshall, being, attempting to be just and fair, says that, well, the tribes, they have a legitimate claim to the lands that they live on. And, we do recognize, the United States must recognize their claims to the land. Okay, so the only thing is, these nations of people cannot possibly have the right to dispose of their lands to anybody except the United States federal government. They can't sell it to a state that is one of the United States. They can't sell it to a foreign power. So what if Mexico? Well, it wasn't Mexico. What if Spain showed up? It would have been Mexico, 1823. What if Mexico showed up and said, "We'd like to purchase this land, around the Rio Grande Valley from you," talking to the Pueblos, okay? And Pueblos could not do that, supposedly. Well, actually, they were claimed already by Spain. That's a different story. It was a bad example. The French can't land in, like Florida and say, we're going to buy some land from the Seminole people here. Okay, that wouldn't fly. That would be a national security issue. You see what I'm getting at? So this original Indian title that John Marshall comes up with is a conceptual thing that he has to, he's kind of shoving it into kind of putting a round peg into a square hole, or a square peg in a round hole. And it's difficult to do it. All right, so anyway, let's look more into this. Marshall expressed the need to extinguish Indian title by purchase rather than conquest. We'll see this later with the other statutes. But what he meant by a right of occupancy was this original Indian title or Aboriginal title. And the rest of these notes kind of repeat what I've said earlier. Before independence, the British Crown had certain circumstances, taken lands by the colonial governments, but then the federal government only could after that. The land ordinance of 1787, the Northwest Ordinance, repeated the terms of a treaty of a little earlier, an Indian treaty up in the Ohio Territory, or what would become the Ohio Territory. And what it said was, well, actually, you have your textbook, right? At the very end of the land ordinance of 1787, do you have that available? The Northwest Ordinance, sorry. You see the Northwest Ordinance in there? Well, at the very end, it doesn't matter. At the very end, it says that the Congress will have only Congress will have the authority to purchase lands from the Indian tribes or take them by conquest in legitimate wars or just wars. Okay, that's something like that. So basically, the authority with the federal government is the United States may purchase lands from the Indians, states can't, or the United States can conquer lands and take them that way. But of course, you read George Washington's letter, and it was like, well, it makes a heck of a lot more sense if we just purchase these lands and do it peacefully. All right. Now, here's something to remember. This will help later. When lands that are any lands that are taken by conquest rather than by purchase are not going to be due compensation under the Fifth Amendment of the Constitution. So compensation at fair market value under the Fifth Amendment, that is under the eminent domain and just compensation clauses, would have some bearing on this, all right? That doesn't mean that deals couldn't be made later. But here's another facet of this. For the United States to recognize an Indian tribe, it generally has to recognize its territory, its possession of territory. And when it recognizes its possession of territory, the United States, all of the Indian policies that is all of federal Indian law apply to that Indian tribe. If there is an Indian tribe who exists but has never signed a treaty with the United States, and particularly a treaty that recognized a claim to land, then there is no recourse for that Indian tribe to ever make a claim against the United States for taking land or not purchasing land for market value. And this is probably very confusing at this point, but you'll see what I'm talking about later on. So there are two types of Indian title. There's the original Aboriginal title, which we can call original Indian title. And then there is basically recognized Indian title. Original Indian title exists without the United States and existed before the United States. Recognized Indian title is that which has formally been recognized by the United States in some treaty or agreement or something like that. So formal recognition is really important. A lot of tribes in the eastern United States never received that formal recognition by the government. Thus today they're still trying to get federal recognition, especially smaller groups. All right, I'll talk about the Indian Claims Commission. We'll have an entire chapter on that. Oh, I'm getting ahead of myself. I must have just flipped through this. All right, what is a taking of land by the government? You know what eminent domain is, right? What does the United States government, what does the Constitution require of the federal government? And then, of course, what does the 14th Amendment require of the states along the same lines when it comes to eminent domain? What is eminent domain, first of all?
So, like when let's U.S. government or now states take private property and then use just compensation.
Okay. So why would they take your own? Why would they show up and take your property?
For public use.
For public use, yeah. It has to, go ahead.
Like if you own like land near a street and they want to expand the street, they can take that land and pay you for what it's worth.
Yeah. So the justification is that the public use will benefit far more people than your private use. So the public is considered to be priority. And so if you don't want to sell, then you can fight it in court, but most of the time, if there's a good reason, just compensation will prevail, or eminent domain will prevail, and you'll get paid market value or higher, for whatever that land is.
Is that like whenever the university here expands sometimes, they can do the same thing?
You're remembering Boone Pickens, aren't you? Or
I don't know,
everything north of Hall of Fame, basically.
Yeah, I've heard stories.
So, I mean, the athletic facilities that we have, there used to be 137 houses where the track and stuff is.
Yeah, it just keeps growing.
Yeah, it's, basically the university bought that, and declared eminent domain, and a couple people fought it, but the university paid good money for it. The question is whether or not university athletic facilities, is that really something that would be public use? Because I would really like to run on that track every now and then, but it's always locked up. It's not really public use. Okay. Anyway. What? So anyway, it's not a highway. It's not a reservoir for water. It's anyway. That was an issue. You're right. So the government has to have good reason, based on the general public benefit. In the case of Indian land, what constitutes a taking is like this: if the government takes land from an Indian tribe and imposes a land use after the taking that is not consistent with the tribe's use, then that's a taking. That's one way of determining that. And we'll see examples later on after the first exam where we'll look into this, okay? And it becomes important. So anyway, no person shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. That's just compensation clause. Okay, now, this is important. I think it's all important, but I'm biased. I'm just realizing that we have too many lights on. Sorry. All right, when getting back to terminology, right? Indian tribes, not individual Indian people, possess Indian title. All right? If you are an enrolled member of a federally recognized Indian tribe and you go out and purchase a home and you have fee title of that house, does that make it Indian country? Yes or no?
And if you buy it on a reservation.
I'm not buying it on reservation. Say somebody buys a house in say 2015 from a non-Indian owner. Does the ownership of that house by an enrolled member of an Indian tribe, does that make that house Indian country? Does it give it Indian title? And the answer is flatly no. No. How about land purchased by an Indian tribe like the Chickasaw Nation? Right? They're buying a lot of land these days. And say they buy a parcel of grazing land in let's say Osage County, outside of their historic area. Let's say Garfield County. They buy wheat land in Garfield County. The Indian tribe owns this land as it's corporate ownership. Does that make it Indian country, Indian land? You sure? If an Indian tribe owns it, they purchased it, fair and square?
Do they have to, go to the court to make it Indian land? It doesn't own Indian land outright, is it?
You guys are sharp. I can't fool you. Exactly. The tribe cannot, if it's in Garfield County, the Chickasaw Nation cannot make that Indian country ever. All right? But if the tribe buys it within their historic boundaries, say like in Garvin County or Pontotoc County, if the Chickasaws buy land in Pontotoc County, they have the option of placing it into what's called federal trust. Essentially, this is like purchasing land and then letting the federal government have it. But the federal government will recognize your tribe's exclusive use of that land, and it cannot be taxed by the state. Now, the interesting thing is, and I actually learned this from your grandpa, all right, is that the Chickasaws generally don't bother to do that, because that means if any land a tribe places in federal trust, guess what? They can't sell it. So they'd rather pay taxes on it than sell it. And it makes a lot more business sense to be able to liquidate assets than just allow it to be federal trust land. In fact, federal trust land is a double-edged sword. It has all sorts of problems, as we will see when we get to allotment. Okay, it brings about all sorts of issues, all sorts of bad issues, generally for the person who has the rights to it. Okay, so all Indian title has been considered to be that of the tribe. The Non-Intercourse Acts protect tribal titles, so no individual claims can be made. Now, after 1985, there was a caveat to that in U.S. versus Dan, which we will cover in the very last chapter of the text. Something referred to as individual aboriginal title. But it's a weird exception, and we don't need to worry too much about that. So any citizen of an Indian tribe may own private property, fee simple title, but that has nothing to do with Indian title. Okay? Fee simple title is just what non-Indians have when they purchase land. And they've paid it off with the bank or with the mortgage company. Tribal trust lands and restricted allotments do remain. Those are the other type of land. Tribal trust lands, restricted allotments. Restricted means there is a restriction against the alienation of that land. Basically, you can't sell it, okay? Because the exclusive title is held with the federal government, and no individual may sell land that has Indian title to anybody, okay, except the federal government. So you can't sell it back to the federal government because the federal government already claims it. So federal trust, let's see. I guess basically I'm just repeating myself again. Okay, so here's the Trade and Intercourse Act of 1790 and how Indian title is expressed in that. It prohibited the alienation of Indian title directly to non-Indians. Okay, so a tribe can't say, hey, we're having a sale today. Any whites want to come purchase some land, or non-Indians, I should say. They can't do that. An individual on an Indian reservation can't sell land that is in federal trust. Now there is, in fact, the majority of land within reservations today is in fee title. Most all Indian reservations, exceptions like the Pueblos and stuff. Most of the land is held in fee, so that's non-Indian title, right? That's fee simple title. But if it's within the boundaries of a reservation, then you have a problem. Then you have an interesting conundrum, right? Because a reservation is the boundaries of the authority of an Indian tribe. So where does that authority begin and end? This is one of the problems. This is one of the questions we will explore throughout the course, all right? For example, okay, the Creek Nation is declared to be an Indian reservation now. Its reservation status is, in fact, intact. And that means the other four civilized tribes, okay, because they had very similar treaties and very similar terms after the Civil War. The constitutions were rewritten at the same time. That means they're also reservations, basically. Right? Now, when it comes to the other reservations in central Oklahoma, I don't know. We'll have to see. But certainly the 5 tribes, eastern Oklahoma, are now reservations. Okay, that means that Indian trust land located within that Indian reservation is as Indian as it gets. And that also means allotted lands within a particular tribe's historic boundaries, the reservation boundaries. Tribal trust lands and individual restricted allotted lands, those are clearly the jurisdiction of the tribes, of the particular tribe. Okay? Question arises in, okay, well, tribes, like states, have regulatory authority. But how much authority do the tribes have within their reservation boundaries when it comes to activities on fee land? That's a big question. Yeah? Okay.
Supposedly now, if you get pulled over by is a native person, like by OHP or something on the highway, they can't ticket you.
I couldn't really understand you.
If you're native now and you get pulled over by like OHP or something like that, like a non-tribal police, they can't ticket you.
They can't?
I guess not. I don't know.
Yeah, they can ticket you.
I don't know because
Yeah, they can ticket you.
well, one of my friends got pulled over like 2 weeks ago by like Pontotoc County police, and she was going 92 to 65, and he said, I can't ticket you because you're native or something like that. And like
Okay, so
they have to
that's
wait
a
for, like,
Chickasaw citizen within the boundaries of the Chickasaw Nation.
I don't know, but it wasn't a tribal, it wasn't a white horse police, so
Yeah.
it didn't.
Well, they may have, that's an interesting point. They may have, no, that wouldn't make any sense.
And then it was just like she posted it on Facebook, and I was like reading all the comments, and it's like part of the McGurk case. They're like now because of the case, they'd have to wait. Like if anything happened.
I think that's more like a Pontotoc County Sheriff's Department, or was it sheriff?
Yeah.
I think it's more like the Pontotoc County Sheriff's Department not wanting to create a test case, So, or maybe, but I can't imagine that being legitimate.
She's going 92.
What?
He should have ticketed her because she was going 92.
Yeah, you should have.
I mean, I imagine that there is something that the McGurk case changed or something.
Yeah, who knows? That's interesting though.
That is very interesting.
Yeah. Now, this may be the case. It may have gone, it may have been easily fought on a matter of jurisdiction. So maybe they just didn't want to bother with it. Well, let's get through this and head out. So only Indian tribes are allowed to convey their lands to the United States via official treaty of cession ratified by Congress or agreement. Indian lands, once ceded, are said to have their Indian title extinguished forever. So you see this term extinguishment a lot. The extinguishment of Indian title, that's the removal of a condition of the land. And that's like the big question about eastern Oklahoma is whether or not Indian title, in terms of the reservation at least, had been completely extinguished. That's still an odd question. Title extinguished. It's, certainly the authority of the tribe still exists in terms of some regulatory authority, but we're not really sure exactly where that regulatory authority stops. All right, just to rehash, Johnson versus McIntosh, 1823, Chief Justice Marshall finds that the United States inherited the spoils of the European Doctrine of Discovery, which was exclusive title to all lands claimed by European sovereign powers, and he thus defined their title, Aboriginal or Indian title, to a right of occupation with the legal just claim to retain possession and use it to their discretion, but not exclusive title to dispose of the land at will. Okay? Only the United States can extinguish an Indian title by purchase or conquest. And purchase is a lot cheaper. That's it. Okay. You all have a great afternoon.